Hello friends, in the series on the income tax cases, today we will discuss the case of JANKALYAN VINIMAY Private Limited versus Deputy Commissioner of Income Tax and others. This case has been reported in 455 ITR page number 456 and the matter has been decided by Calcutta High Court and the date of the judgment is 7th February 2023. In this case, the assessee moved to the High Court for an issue which is the problem of every assessee who is before the CIT appeal since 3 or 4 years, for which even the notice of hearing has not been issued by the CIT appeal. This is very unfortunate for the direct tax litigation system in our country, that from the date the CIT appeal has become the faceless CIT appeal. From that date, if the appeals have been filed by the assessee, then there is no notice from the CIT appeal for the hearing of the case of the assessee, and the situation is a status quo since last 3 to 4 years. The problem for the assessee is that due to the faceless assessments, a lot of high pitch assessments have been done because the assessing officers are not able to understand the submissions, or if the assessee is giving the submissions, they are not in a position to understand them for the reasons best known to them. So in these type of situations, numerous demands are pending of such an amount which for an assessee is practically not possible to deposit, and even the 20% of that demand is not feasible for almost all assessees to deposit because the demands are so high. Like in case of bogus purchases, the whole amount has been added. In case of allegations of the entry business, accommodation business, the whole amount of loan has been added without giving the opportunity of being heard, without giving the opportunity of cross-examination, and the demands of crores of rupees are pending in case of assessees who are filing the return of rupees 10 lakh. So there is no fault of the assessee has filed the appeal, there is no hearing of the assessee case, the assessee has filed the stay application, the stay applications has not been disposed of in spite of several reminders, and this was the issue of the assessee in this case also. The assessee filed appeals in 2018 against the high pitch assessments and filed the stay of demand. In 2022, after giving numerous reminders, the department rejected the stay application of the assessee, for which the assessee moved to the High Court. The High Court said that there is no fault of the assessee. There is no denying the fact that there are high pitch assessments. There is no denying the fact that the assessee has filed the appeals in time. There is no denying the fact that there is no hearing since last 4 years, and there is no denying the fact that the department has not disposed of the stay of demand application in a sensible manner. So the High Court directed the CIT appeal to hear the appeal of the assessee on priority and to give the complete stay till the disposal of the CIT appeal, and there should not be any coercive action against the assessee till the CIT appeal is disposed of. Friends, this case is very much needed because you just imagine the pain of the assessee, that the assessee is filing the appeals, and because the whole department is faceless, the department cannot even go to the department and can say that please hear my appeal on time. And this is a very ridiculous situation for an assessee, that the assessee has to go to the High Court for giving an application that please hear my case. If the department will hear the case on time, the department will get the tax if the demand will be confirmed. But this is very unfortunate for our fiscal laws as far as the direct taxes are concerned, because the assessee is in a very pity situation, because the demands are pending. Even the assessee cannot sell his properties. The properties are attached, the bank accounts are attached, the coercive actions are taken, but the appeals are not being heard. So From this case, it comes to the conclusion that, and it is very unfortunate for an assessee, that for early hearing before the CIT appeal, the assessee has to move to the High Court, because every assessee cannot even afford the cost of the litigation for going into the writ into the High Court. And sometimes in the writ petition also, it takes 3, 4, 6 months to get disposed of. At the end of this video, once again, I am repeating the name of the case. The name of the case is JANKALYAN VINIMAY Private Limited versus Deputy Commissioner of Income Tax and others. And this case has been reported in 455 ITR at page number 456, and the matter has been decided by Calcutta High Court. The date of the judgment is 7th February 2023. Thank you, friends.